Thank you, Chairman. I will also have to be brief, so what I will do is to reduce my presentation to one preliminary remark and then 3 points. I will follow your example. My preliminary remark is that the title of my contribution says when the alternative methods become real and effective. And the first consideration is that for the benefit of LDCs, of their development and stability, methods of dispute settlement must be real and effective. And so the goal which has to be reached is not only in a more general perspective, and for the benefit both of the host state and the investor, is not only determining who is in the right and who is more powerful, but to settle the dispute and proceed. My first point is negative, because we cannot hide the fact that investment arbitration has encountered a certain criticism, a certain unpopularity, being accused of being non-democratic, non-transparent, and mostly excessively costly. And so some countries are withdrawing from treaties providing for arbitration in matters of investment disputes. And originating myself from an EU country, I must also recall the position of European institutions for the improvement of the traditional forms of investment arbitration. But at the same time, whether the criticism against arbitration is valid or not, which is not for us to say today, it is important to consider, I think, that many countries are targeting effective ADR system as a method for fostering FDI. And so here I go to the second point, which is more positive, because worldwide, we had a very wide revision of ADR legislation in many countries. And in the past 2 years, many countries approved entirely new codes of civil procedure and ADR and investment arbitration. We already heard about Myanmar example a few minutes ago. And in the same time, in the African continent, many countries have taken initiative to develop ADR mechanism in general, so to reduce litigation in court, and so showing the momentum for ADR in the region. It's also interesting to consider that at a regional level, various existing institutions are now offering a wide range of really effective ADR services, granting users major attention to transparency, to time and cost control in settlement procedure. And even new institutions for dispute settlement have been implemented. So some Asian countries were firstly hesitant towards ISDS methods, but later many of them largely committed to treaties embodying ISDS mechanism and entering into bilateral and multilateral investment treaties, as well as free trade agreement with investment chapters providing for arbitration. So given the potential for investment of many developing countries, arbitration can still be considered the predominant dispute resolution mechanism. But still, ADR, and I'm going to my third point, ADR is not only arbitration. ADR is also, for instance, mediation. And the program we are discussing today also provides for supporting LDCs countries in mediations in order to identify expert mediators. And most recent negotiations related to trade agreements demonstrate that states, investors, and all relevant stakeholders are paying great attention to mediation. Mediation has long been used to manage conflicts in different sectors, for instance, even in construction projects, but not less frequently, I would say, to settle investment disputes. nowadays, institutions are carrying out several initiatives on mediation, and states are negotiating treaties incorporating mediation as a form of investor-state dispute settlement. Just two examples, very quick. One is the Comprehensive Economic and Trade Agreement between EU and Canada, but also the EU-Vietnam Free Trade Agreement. So what can be the interrelation between mediation and arbitration? First of all, mediation might precede arbitration. Mediation could play a role in a sort of cooling off period after a dispute arises. And typically, we know that investment treaties often leave to disputing parties the choice of means by which the settlement might be achieved. Mediation could also take place during an arbitral proceeding. And what's the use of that? The use could be to reduce, to refine, narrow, probably, the issues to be addressed in the arbitral proceeding. Mediation might even offer an alternative to arbitration, so directly incorporated into investment treaties themselves. As a consequence, before initiating arbitration, parties could be required to make a good faith attempt at mediation, or at least discuss the possibility of resorting to mediation. Still, we know, many experts sitting here today well know that mediation still presents major difficulties, especially if we want to consider mediation as a substitute for arbitration. First of all, the major problem is enforceability of mediation settlement, which do not benefit, okay, I'm almost at the end, of the enforcement regime under ICSID Convention. So, just to conclude, I think that a sort of multi-step approach could be particularly beneficial for LDC countries in order to find out, maybe not consider either or choice, but considering the most appropriate settlement method according to the case. Thank you.